Testing, testing, 1, 2, 3.
Good morning, ladies and gentlemen. Judge Lee and I are here, and as you can see, we are also joined by Judge Jackson Acumi, who is appearing remotely. So I'm going to keep the traffic lights moving, and we are now ready to hear Mr. Atkins from you in our first case for today, GrubHub versus Relish Labs, LLC, number 22-1950.
Just lean back a moment, trying to get properly situated on the video.
Certainly.
May it please the court. The district court's order has at least 3 instances where the court cites law and then does not follow it. Weighing and balancing all of the factors, a side-by-side comparison, and drawing an adverse inference against Home Chef for not doing a survey. For example, on 812, the court cites Eli Lilly and says proper weight should be given to the various factors, and yet the court does precisely the opposite. In footnote 2 of 812, the court says, I'm not presently considering those 4 factors in this court's multi-factor test. That means that they took the multi-factor test, did not consider, weigh, or balance those factors in determining to deny the preliminary injunction motion. Second, on page 812, the court cites AutoZone and says, don't do a side-by-side analysis. And that does exactly that on the following page. You don't do a side-by-side analysis if it does not show up in the marketplace that way. And here it does not show up in the marketplace that way. The R&R did a wonderful job of explaining that and referencing how both parties said it does not show up side by side. That's on page 837 of the R&R.
So can I ask you about, as I gather, we have before us in this appeal really only 3 of the factors out of the 7 that this court has identified, since 4 of them seem to be conceded by all sides, similarity to the products and so on. So I'd like you to talk a little bit about intent, because this is a reverse confusion case, and the circuit seemed to be a little different in the way they approach the intent question.
Yes, there's quite a disparity throughout the country with regard to intent. And in 1992, in the Sands case, this court said, hey, there's reverse confusion. Found that there was reverse confusion. And yet, intent is essentially irrelevant in a reverse confusion case.
Now, did you understand that to be across the board? I certainly can see in a reverse confusion case that it's not meaningful to talk about intent to palm off your products as though they were somebody else's, because that's not the point. But if you look at, for example, what the Ninth Circuit has said, in a reverse confusion case, and I'd actually like to know what your theory is in this case, that the junior user is somehow swamping the market, is actually pushing out the goodwill or the market position of the senior user. Is that in our law, or would we need to modify our law to recognize that?
So I believe your question is, do you need to modify the law or clarify from Sands with it's essentially irrelevant? I think the answer is yes. And where I would invite the court to look is the reply brief 25. On page 25 of the reply brief, you will see that McCarthy, which was cited in GrubHub's response, collects cases and recommends at the top of page 25, it says, McCarthy, in reverse confusion cases, courts should ask whether there is some evidence that the junior user, when it knew of the senior user, in this case it did, that's undeniable,
right,
was at fault for not adequately respecting the rights of the senior user. And so the answer to your question is yes, I would recommend that intent be found, but if it's not, then the district court made a mistake by applying intent and finding it in favor of GrubHub. And that would be a legal error.
Right, so, well, okay, so you're arguing the alternative then, that if there is no intent factor at all, then there was a mistake at the district court level, not the magistrate judge, by the way, but the district court level in applying it. Because, we really need to dig down to intent to do what, because in the normal cases, it's intent to pass yourself off as the other party. And in the reverse confusion cases, it's of course not.
Right. So in a forward confusion, it's intent to pass off.
Right.
You make some bootleg Disney DVDs and you say, here it is. That's intentional and passing off. In a reverse confusion, it's, did you know about the mark? And did you intend to swamp and overwhelm the market, as is the case here?
Can you tell me, we may not be here right now, but just for my edification, your theory of damages in this kind of reverse confusion case?
I'm not at liberty to discuss those, and I'm not conversant in those at this moment.
Okay.
But the damages would be...
it was still kind of a theoretical level, because say in antitrust cases, sometimes damages are for an overcharge, sometimes they're for exclusion from a market, sometimes they're from, a very broad heading level.
I'm sorry, I'm not quite following.
I'm not asking you for a dollar sign. I'm just asking for theories.
Well, for example, GrubHub, our client Home Chef.
Home Chef, yeah.
Home Chef, thank you, started here in Chicago in 2014.
And they're in a slightly different niche of the market from that which GrubHub occupies, it seems.
Actually, no.
No?
GrubHub delivers meals as well as groceries. As a matter of fact, I believe it's Exhibit MP22 shows a printout from behind a declaration from a Kroger paralegal. Hey, here is Kroger delivering groceries. Also, the vice president of growth at GrubHub at 46-4, Exhibit E, page 98, said, this is what we're delivering, including groceries. And GrubHub's answer to the counterclaim, docket entry 39, page 32, also said, we deliver groceries. But now coming back out of the weeds, you said, hey, aren't they different products and services? The answer is no, because they're both meal delivery. GrubHub delivers groceries, but Home Chef also has their ready-to-eat meals delivered by GrubHub's competitors, DoorDash and Instacart.
Okay. So, counsel, you keep referring to GrubHub, and we talk about GrubHub, and GrubHub is all over the briefings. And I think that both sides seem to state, or at least acknowledge, that GrubHub itself is a pretty strong trademark, right? And so perhaps can you discuss which market is that your theory focuses on? What is it, the Jet House mark versus the GrubHub house logo? And what are we to make of the other side's argument that, in fact, because GrubHub is such a strong trademark and used in combination with the alleged infringing trademark, that addresses many of Home Chef's concerns?
Yes, that's a great question because it's complicated. As you'll see in the briefing, we've got, I say we, Home Chef has 3 different categories of marks. One is the home alone, which is really important. They use that alone, and they use it to co-sponsor. So you'll find the house, the Home Chef house, it's referred to so many different ways, I apologize, but the Home Chef house plus Impossible. Impossible is a vegetarian meat, and you'll see Home Chef with Impossible.
But without the words Home Chef underneath
With
the
just,
little house.
just the house
Yeah,
alone.
just the house, yeah.
It's in Shira Schwartz's declaration, probably about pages 8 or 9. And they do that often. They also use the Home Chef mark alone. I'm coming back out to answer your question. That Home Chef mark getting used alone is really important. It's what allowed Home Chef to grow as much as it did. So that mark is used alone. It's used with the word mark Home Chef, and then separately there is the Home Chef word mark. It's not the Home Chef word mark, but it's both of them. And the USPTO looked at the Jet House alone and said, that's confusingly similar and sells the similar products to both the Home Chef house mark and the Home Chef house mark plus the word mark. So I'm trying to be precise. So,
But has GrubHub ever used what you call the house or the Home Alone mark in promoting its services and products?
yes, they used it alone, which is in Exhibit 47-1.
But in those exhibits, it seems like it was always closely connected or in conjunction with the wordmark GrubHub, right? And so would someone going into the website, I think there was the websites, there were some screenshots of websites and what have you, ever think that, or would a consumer think that GrubHub was using the Home Alone logo apart from its wordmark?
So, two things. They don't use it just with GrubHub. They use it with Seamless. That Vice President of Growth Kirshen at 46-4 shows the mark where the Jet House mark plus Seamless. And all throughout the briefing, it's been like, oh, just forget about Seamless. It's going to go away. It's going to go away. It's now.
No, I take it your theory is if the Jet Home could have GrubHub under it and could have Seamless under it, could easily have Home Chef under it. So people could be confused.
Yes, but it goes farther than that. If you take the Home Chef registered mark, just that mark, and say, oh, look, there's GrubHub, forward confusion. But if somebody comes along and looks at the GrubHub or Seamless mark and says, oh, there it is, and then later on looks at Home Chef's home mark, which is used very much, and now they can't use it alone because it looks just like GrubHub, that's the reverse confusion. It's, hey, Home Chef can't use its mark alone.
Counsel, I'm still struggling at the level of our standard of review, though. We're not at the summary judgment stage, which is where a lot of the cases that you quote in your brief are from. We're at the preliminary injunction stage, where, as you know, we have this highly, extremely high burden. It's plausibility. And so I understand that you do believe the district court should have weighed factors differently. I think you were trying to tell us in your opening, but you've cited a variety of cases. Many of them don't negate the plausibility of the district court's findings. Despite your view that he should have weighed differently, more like the magistrate judge did. So can you point me to what part of the findings of the district court, based on the evidence, is simply not plausible?
I'm sorry, it's not
not plausible at this preliminary injunction stage.
Well, Your Honor, this is an abuse of discretion analysis. That's the standard of review. And the failure to apply the law correctly is an abuse of discretion. And here the law was applied incorrectly in at least three different ways. One is considering, weighing, and balancing the 7 factors. 4 of those were set aside in a footnote and said, I do not presently consider them.
Is that a fair consideration, or was the court saying GrubHub is not even contesting 4 of these factors, and those factors have been found in Home Chef's favor? Let me concentrate on the 3 contested factors. That how is that error as opposed to focusing on what's really in dispute?
Because if you look at footnote 2, and I apologize, it's only a footnote, it's 2 sentences. The first one says, we do not presently consider it because they didn't object. And the second sentence is, okay, even if I did consider them, they wouldn't make a difference, but they weren't considered. And it's a multi-factor test where you have to balance. First, you have to consider, weigh, and balance. And the reason is because they're all related, all those factors. But to finish up, the rest of your question is, there was legal error with regard to side-by-side analysis of similarity. Case law says you don't do that. The last one is the adverse inference. The judge said, you know what, I'm holding an adverse inference against you, which is contrary to the same law that he cited. I'm sorry, that the district court cited, saying, I'm going to hold an adverse inference against you due to the survey. I believe I need to reserve the rest of my time.
If you would like to reserve your last minute for rebuttal,
Thank
that's
you.
fine. We'll now hear from Mr. Bernstein.
May it please the court, I'm David Bernstein with Debevoise and Plimpton, and we represent GrubHub and Jet. So I'd like to start with Judge Jackson Acumi's question, because I think that goes directly to what the standard is. The question here is whether the district court found that there was no likelihood of confusion, and whether that finding is plausible. The plaintiff, effectively the plaintiff, because we were a declaratory judgment plaintiff, but the movant in this preliminary injunction had to make a strong showing of a likelihood of success. And as this court has found, and as Your Honors have already identified, this court has said the three most important factors are similarity of the mark, actual confusion, and intent.
But what do we do when intent, which is where I wanted to start, at a minimum does not operate the same way in a reverse confusion case? It's not as though anyone thinks that GrubHub is trying to make everybody think it's really Home Chef. You know, GrubHub is a long-established company. So we have said in the context of reverse confusion that intent is simply not useful. Now, perhaps you could go further and say, you know, is there an intent to deprive to deprive Home Chef of the commercial value of its marks? We can get into that. So that factor is at least questionable. Actual confusion in a preliminary injunction case doesn't need to be shown already to have happened. It's that the defendant's use of the mark is likely to cause confusion among consumers. That's our sport fuel case, but it's plenty of other cases as well. And there's actually quite strong evidence of the similarity between these marks in both appearance and suggestion. So why isn't it the case that you have to go back to the uncontested factors, say, okay, these are similar products, there's concurrent use, consumers are not going to be exercising much care, they just want a dinner, and it's a strong mark, the plaintiff's mark is. Why isn't a reweighing necessary?
So there's a lot there, Your Honor, and I'd like to unpack it, if I may. First of all, there is a claim of both forward confusion and reverse confusion. And so the intent factor is surely relevant on forward confusion.
But in the briefs, unless I read different briefs than everybody else, I mean, certainly the emphasis seemed to be on reverse confusion.
I think the plaintiff's briefs are still pushing both theories, but yes, reverse confusion is what the theory they're pushing now. And Your Honor, in the Sands-Taylor case, which I believe Your Honor was on the panel, that was the classic example of reverse confusion. You had a very small company, a small Vermont company. It had been around for 180 years. It had a small beverage business as part of that, and it was using Thirst Aid as its trademark. And a gigantic company, PepsiCo and Gatorade, swamped the market. Your Honor, in the 30 years I've been practicing trademark law, I have never seen a reverse confusion case where the senior user is itself a behemoth. Home Chef is $1 billion business.
But it doesn't mean that they don't have economic investments in their trademark.
They do, but the theory of reverse confusion doesn't work, and I'll tell you why, Your Honor. The theory of reverse confusion is that you've got a small company that's not well known, like Sands, and they want to be able to expand their use of Thirst Aid. But when they use Thirst Aid, because Gatorade has swamped the marketplace, they can't use their own trademark.
But the allegation here is that without, I guess, putting Home Chef underneath the little house, you know, every time, you have in fact precluded it because ordinary people just on the street looking at this little house with the fork and knife are going to confuse the two. And that's what the PTO person said, certainly not conclusive evidence, but it's interesting evidence.
Well, the PTO did not look at the market issue, and to Judge Lee's point, the accused mark, the market issue here, is the Jet mark, the house and cutlery mark, used with GrubHub, and also to some degree with Seamless. That is being phased out, but Seamless is a very well-known mark, at least in New York. And Your Honor may not be as familiar with that brand, but it is one of the brands of GrubHub.
But I thought that was a damaging fact for you, because if the Jet house can apply to both GrubHub and Seamless, then why can't it apply to a third or a fourth or a fifth brand name?
Your Honor, these are questions of fact. And I think when I read their briefs and I listen to Mr. Atkins' argument, what he was arguing today is basically for a do-over, asking this court to substitute its judgment for the district court. The district court had all of these facts before it. And what this court has said is that the standard of finding a likelihood of confusion in this circuit, it's a question of fact.
Oh, sure, but the facts need to be found under the correct legal framework. The Supreme Court has sort of blended this in all sorts of, think Pavlik and LaFleur, think of all kinds of cases where it said if you apply the wrong framework, garbage in, garbage out, basically, you're not going to get the right facts.
So let's take a look at the three most important elements in this court. You asked about intent, Your Honor. Mr. Atkins talked about McCarthy. This is what Professor McCarthy says about intent, and this is on page 35 of our brief. He says, in the reverse confusion context, the question is, did the defendant knowingly proceed to use a similar mark after reasonably determining that there'd be no conflict? That does not qualify as the kind of intent that would favor the senior user. The intent issue in Sands was very different, and I would say, Your Honor, that it's a question of fact as to whether the intent here shows an intent to swamp the marketplace and destroy the goodwill in their mark. That's not what the district court found. When we look at, and it is true that there are cases in this court.
Did the district court ever ask the right question about intent in a reverse confusion setting?
The district court did, Your Honor.
Oh, sure.
The district court talked about the use of the brand name and what the intent here was. Remember that my client Jet developed this house and cutlery logo before Home Chef ever had their logo. We've been using that logo all around the world in connection with our businesses in many countries. When they acquired GrubHub.
Are you arguing that you're not the junior user?
In the United States, Your Honor, we are, but it goes to the question of intent. In other words, when my client acquired GrubHub here in the United States, they wanted to bring the same trademark that they've used all around the world, that is known as a global brand, and use that here in the United States. So they're linking on a global basis their business. What the district
Now
court
you're back
found-
at forward confusion. I thought you were supposed to be discussing reverse confusion.
Yeah, so it goes to reverse confusion, Your Honor, because what the district court found was there was no intent here to swamp the marketplace and destroy their trademark. Indeed, when you have such well-known trademarks, these are both billion-dollar companies, when you have such well-known trademarks, consumers are adept at distinguishing between them, especially when we're talking about delivery of food to the home. And so having a logo that's a picture of a house and a picture of cutlery, that's hardly the most distinctive or creative logo. What the district court found is that the most salient part of the mark is actually the GrubHub name. And that on both a forward and reverse confusion context would mitigate against confusion. Now, on the intent factor, Your Honor.
But you all are conceding that Jet and GrubHub do use the mark alone without the name at times.
No, we're not, Your Honor. That's not true of GrubHub. As I think it was Judge Lee pointed out, when we do use it, it is always in conjunction with the GrubHub name or Seamless powered by GrubHub until Seamless is phased out. And it's very deceptive, I'm sorry to use that word, in Kroger's brief, where they cut and paste tiny portions of our website to suggest that we use the logo alone. That's on the GrubHub website. They've photoshopped out the rest of the website. When we use the mark, it's always with GrubHub. And that was a key reason why the district court found, as a matter of fact, and this is a plausible finding, that the USPTO's decision is not probative here, because the USPTO did not consider the mark along with GrubHub. The USPTO only looked at the mark with the logo alone. Now, when Jet announced that it was going to acquire GrubHub, it applied for that mark. But ultimately, when the acquisition was completed a year later, what GrubHub decided was that it was always going to use the mark with GrubHub, and again, with Seamless powered by GrubHub for some period of time. So on intent, there are cases, Your Honor, where the courts have said intent is essentially irrelevant, but it depends on the circumstances in the reverse confusion setting. And it could still be relevant if the court finds that, as Professor McCarthy says, and again, that's on page 35 of our brief, that the intent issue is, did you intend, in the reverse confusion context, to push their goodwill out, to basically steal their trademark? There's no evidence.
It's hard to get, I could certainly see moving in that direction, but looking at this court's prior cases, we've spoken pretty flatly about this. Intent is irrelevant in the reverse confusion inquiry. Now, you may be arguing that that's not the correct rule of law, in which case we'd have to reconsider, but that's what we've said.
I actually do not believe, Your Honor, that this court has said intent is irrelevant. I believe this court has said it's essentially irrelevant.
So how about Fortress, Grand, Warner Brothers, the seventh factor, intent is irrelevant in a reverse confusion analysis because the junior user is not trying to profit from the senior user's brand.
And look, I think that it is a fact question for the district court. I do not think that this is a legal error for the district court to consider intent. And I would note, by the way, that Kroger made a huge deal about intent and our alleged bad intent before the district court. It's only now that the district court has found we did not act in bad intent that they're saying it's irrelevant. But let's assume it is. Let's assume that for reverse confusion, intent is neutral. Okay. Because let's assume it's neutral. We still have the two of the other most important three factors, being similarity and confusion. And the district court found, plausibly, without clear error, that those weighed heavily in our favor. Now, Mr. Atkins really, I think, misrepresents the footnote in the district court's decision on the other four factors.
It seems odd to me, though, just looking at a common sense level at the little house with the fork and the knife for Home Chef and the Jet house, I'll call it, aside from the fact that, the colors are a little different, but the claims for colors no one's making too much of. They're very similar.
Respectfully, Your Honor, the question of law is not whether you sitting on this appeal panel think they're similar. The question of law is, in the marketplace context, when the marks are considered as a whole, would consumers be confused?
Right.
And the district court, considering all of the evidence, including the surveys, found that there was no likelihood of confusion. Now, Mr.
But there
Atkins
were some real problems with those surveys, too. The Ever Ready survey.
Your Honor,
My goodness.
I'm going to say that those are questions of fact, and the district court considered the criticisms.
So why have a court of appeals? We get to look and see.
Because the Court of Appeals looks at two things. Was there an error of law, and were the facts clearly erroneous? And
Was
when you
there an
have
abuse?
surveys-
I would correct you and say, was there an abuse of discretion in the decision to grant, not to grant in this instance, a preliminary injunction when more will happen in a case?
And what is the preliminary injunction? Here it's preliminary injunction is about preserving the status quo. For well over a year, we have been using this logo. And they have, in well over a year, we've had hundreds of millions of transactions under this logo. They come forward with 2 social media posts, and I'd like to talk about those.
Sure.
The first one is clearly not confusion. It's somebody who says, oh, look at this logo. There's elements that are similar to the other logo. That's someone who recognizes they're 2 different companies, that they're not related. And the district court plausibly and properly, in my view, but certainly plausibly found that that's not evidence of confusion. And the second one is someone who poses the question to Kroger, have you and GrubHub merged?
Right.
And I think you could say, okay, there's one instance where someone didn't say, wow, interesting that you merged, posed the question, did you merge? And the district court says, that is something that's entitled, at least to my considering it, but it is overwhelmed by all the other evidence, including the surveys. And Your Honor, respectfully, I don't agree that these are flawed surveys. There's no perfect survey, we know that. But the district court carefully considered the objections to the survey, carefully considered our responses to that, and found as a matter of law that those surveys were probative. And what did the surveys found? On both forward and reverse confusion, 0. Now, I've been doing this for a very long time. You don't see 0 in surveys.
Well, because they only showed people things that were the little house with the words Home Chef under it, and then they were asked, whose company is this? And they said Home Chef.
And they're also asked all the other questions. Are they affiliated with anyone else? Do they have a business relationship with anyone else? Do they have a
And
sponsorship?
this is why I don't think you can dismiss the USPTO letter so quickly. The USPTO looked at Home Chef, the logo alone, the trademark alone, and with the label.
But
And
Your Honor, the USPTO does not consider reverse confusion. The USPTO was focused on forward confusion only.
this is relevant to the confusion factor that you're talking about. If Home Alone uses it without a word mark as well, which it does, then there could be confusion. That word mark could just as easily be GrubHub or Seamless.
I know my time is up. I'd love to answer that response.
Please answer
your
the judge's question.
So, Your Honor, what the USPTO looked at was only the Jet house mark and the Home Chef mark. But that's not the
But it
proper
looked at
comparison.
two Home Chef marks. It didn't just look at one Home Chef mark.
Well, it was the same mark, one in color, one was not. But the key thing they were missing, Your Honor, the key thing they were missing is that they were never looking at the Jet mark with GrubHub. That is the comparison that the district court said, and by the way, the cases are legion on this, that the USPTO's assessment, this is an initial assessment by a trademark examiner, that assessment is not entitled to weight when it's comparing different marks not in the marketplace. And remember, too, the PTO did not have all the other evidence that was before the district court. It did not have the two surveys. It did not have all the fact evidence. And so, Your Honor, the district judge made a finding of fact that the USPTO office action, an initial office action, was not entitled to be a determinative factor here. The judge considered it. He didn't disregard it. He considered it, but he found that it did not overwhelm all of the
Okay.
other evidence of
All right.
confusion in this record, of lack of confusion in this
Any
record.
other questions from the panel?
Thank you very
All
much,
right.
Your Honor.
Thank you, Mr. Bernstein. Mr. Atkins, we'll give you 2 minutes to balance things out.
Thank you, Your Honor. I have 4 quick points, one of which is the USPTO. That's 128 pages with both the Home Chef website and the GrubHub website printed out and included in it. There, the examiner looked at the similarity of the marks and the similarity of the products. Second, in regard to Judge Jackson's question, Mr. Bernstein said we're looking for a do-over. We are not. If a court does not apply the correct law or rests its decision on a clearly erroneous finding of material fact, it is an abuse of discretion. You need to look no further than to page 810, that top paragraph, where the judge says, hey, you've been coexisting for a year. Not correct. Material fact, wrong. Second, I'm giving an adverse inference because Home Chef, you didn't do a survey, contrary to case law. 810, so that's the specific site I believe you're looking for. The judge said coexistence for well over a year. The third point, yes, Home Chef had $1 billion in sales in 2020. And do you know how they got there? Because a young man named Pat Patelik started in 2014 just down the street in his apartment delivering meals. In 2014. In 2018, he'd grown that business using that mark, that Home Chef house mark, to grow the business to $250 million in 2018 when Kroger merged with it. By 2020, COVID had hit and sales had gone up, in large part because Kroger started selling Home Chef's carefully curated and obtained products. The question is, well, you have $1 billion in sales. What about the other side? Well, a 27 billion euro company called Takeaway paid $7 billion to buy GrubHub in 2021. And what did GrubHub do? Their Vice President of Growth, Kirshen, at 46-4, paragraph 26, put it best. Brand awareness is critical to market share. So the first thing they did was put the Takeaway 27 billion euro mark that you see in their brief with a house, and each country has it, and says, bam, you're now part of the Borg.
Okay, you need to wrap up. Thank you very much. Thanks to both
Thank you.
counsel. We will take this case under advisement. Our second case for this morning is National Police Association against the Gannett Company. We'll let the courtroom clear out for a second before we start. Okay, I think things have calmed down a little bit. So, Mr. Bopp, you may begin.
Thank you very much, Your Honor. May it please the court. In the normal situation, a cause of action for defamation accrues upon publication. Now, there are exceptions to that, such as republication. And so the question of when does a publication occur and who does it encompass is an important question in the law of defamation. But it can also arise under Section 5772, which is the cause of action brought by the National Police Association. This is where a cause of action accrues after publication when the defamer finds out that the statement, the defamatory statement, is false, as
So,
is
Mr.
alleged
Bopp,
here.
has the Indiana Supreme Court ever recognized that scope for 5772 of the Second Restatement of Torts?
I'm sorry, I had difficulty hearing you, ma'am.
I apologize. Has the Supreme Court of Indiana ever found a claim under 5772 of the Second Restatement of Torts of the sort that you are arguing for?
No,
Okay, thank you.
no. And however, this court and the...
And let me ask you, has any court in the country, adopted this continuing publication reading of 5772 that you are proposing?
There are two cases that we cite in our brief in which they appear to have done so. But it is true that there is not a case on point that we can cite to, nor is there a case on point that says there is no such action or that we repudiate 5772. In the Trackett case, by decision of this court, the Seventh Circuit recognized that Indiana would recognize a cause of action under Section 5772.
But in a much more limited way than you're arguing for.
Well, that's true, and
I mean, a significantly different way, in fact, dispositively different.
well, let me be clear about that. There's nothing in the Trackett decision that excludes our cause of action.
But Mr. Bopp, as you well know, we are here under the diversity jurisdiction, and the number of times this court has said that's not the time for a federal court to get creative is legion. And I would think if this is what you want, you should go either to a state legislature, you should find an in-state defendant and sue in state court so that removal is impossible, and see what the state court says. I see not a hint from the Indiana Supreme Court that they are ready to take the step you're suggesting.
Well, both in Trackett and in the Packett and Perkins cases, this court did decide whether Illinois and Indiana would recognize certain doctrines under defamation, such as the single publication rule, and in Trackett, whether or not a cause of action for 5772 would be recognized by Indiana courts. Now, if you are not inclined to do that, we have moved for certification of the questions.
But
to the
certification is appropriate only when we are in some doubt about what a state court would do. So, for example, and you know all of this perfectly well, if the intermediate appellate courts of Indiana had been pushing in this direction, if there was precedent from the Indiana Supreme Court saying, this isn't the case, but we're open to the next case, there are signals that one gets that causes one to think, well, maybe the state Supreme Court will do this. But what I see from Indiana is just a very standard rule of law that follows the single publication rule that would, by itself, I think, bar the claims that you're trying to bring on behalf of your clients. Maybe that's bad public policy, maybe it's good public policy, but it seems to be what Indiana does.
Well,
And you didn't discuss the Pippin case at all, which I realize is an Illinois law decision, but the
we
facts in
cited,
Pippin is,
we did it in the reply, cite both and discuss.
they're very close to this case and not favorable to you.
Well, but this is the critical difference that is that when does a cause of action accrue? And in Pittman, the argument was that because he notified the publisher after the publication that he had not gone into bankruptcy, that affected a claim about the original publication and whether or not there was a defamation in the original publication. I agree that the Indy Star, when they originally published this article, that they did so on a reasonable basis. There was no required mens rea that they knew that the information was false.
Having said that, then wouldn't it be essential, if we were to accept your theory, to create an exception to the single publication rule? We've all agreed now, the original publication met the relevant legal standards for care, for whatever, it was okay. So we would need some theory that would allow us to say, well, but we're not going to follow the single publication rule here.
The single publication rule is applicable to a 5772 because the question there would be, as it is with the original publication, the question is how many causes of action have accrued? Is it one? Okay, because for instance, if the statement is made in one edition of a book, one cause of action accrues. Here, when the cause of action accrues because the defamer has knowledge that he's made false statements and wants to continue to do so, there's a duty to remove that defamatory material. And the question is, how many people...
To remove, you've said, well, or at least look at Professor Volok's article, could be a duty to remove, it could be a duty to put an explanatory paragraph at the header, or, there are all sorts of things, and as I understand it...
Yes, to mitigate the defamatory effect.
You think this claim accrues when the allegedly defamed party goes to the publisher, the person who, in the defamation sense, the person who published, whether it's the reporter, the newspaper, and says, you made a mistake, we aren't a scam, or you made a mistake, I'm not bankrupt, or you made a mistake, I'm the wrong person, it was a teacher at a different school, is one of the hypotheticals that Professor Volok uses. So somehow that seems to trigger, and that could go on forever into the future with things on the internet as they are.
Well, not more than once.
Oh, sure it could, because there could be a new mistake.
Well, if the... or
it could be further investigations, right? And so if you have, it seems...
There are a lot of rules about this. If there is, if you're suing somebody for publishing a communication, you've got to bring, all your claims. You can't tuck some away. If you have defamation claims about this communication, you better make them, all right?
But you might not know about one of them.
And one time. Right?
So say an article has 5 statements of fact. And in year 1, the alleger, the claimant says, oh, you know what, I investigated this one fact, and that is completely incorrect. And then year 2, they said, you know what, that second fact is incorrect too. Year 3, the person says, oh, well, you know what, I looked into this, and that fact also is incorrect. So would that claimant have 3 separate claims?
No, because there are rules about bringing claims against a particular party regarding a particular situation or
So can that person then wait until, say, instead of sending that notice on years 1 and 2, just wait until year 3 to say, now I think I'm just going to let them know everything I found?
The rules require, as I understand them, you to bring all your claims against this defendant regarding the particular circumstances under which the case arises.
Is there any time limit that you would impose, or any sort of a limitation on when such a claim can be brought?
There's no recommendation for that.
Well, I guess I'm wondering what your thoughts are and what sort of limiting principle you think a court would apply if the court adopted a continuing publication theory. Continued publication.
Right. As Judge Wood said, the legislature, of course, can regulate this and impose reasonable limitations and restrictions on this. But that's not a reason to just disregard it and not recognize it as as a legitimate claim. Now, this is a very limited claim. In other words, you have to, it only creates a duty to remove or correct or modify, doesn't require you to retract. It must be regarding communications that are under your control. So, it's on their website, but it's not, if it's on somebody else's website, they have nothing to do with that.
Before you go any further, could you please explain to me the difference that you're urging between retraction and removal?
Well, retraction requires a statement by the IndyStar in this case. Where they say, we were mistaken, or now we know we're mistaken, and this is just to stop the defamation from continuing.
Okay.
Just stop it.
So you just delete the sentence and it goes off just like the European right to be forgotten?
Well,
that's actually what you're arguing for, I think, is a U.S. adoption of what the EU has struggled with for years.
It won't be forgotten. It won't be forgotten. If the IndyStar article is deleted, there are plenty of other articles that cite to the IndyStar article. And let me tell you, think about this. If you Google National Police Association, is the National Police Association legitimate? The very first hit is this article, the 2019 article, that they know now is false and defamatory, and they don't want to do anything about it. They want to forever defame this organization regarding a false, what they know to be now a false statement. And all we want them to do is stop doing that.
So
That's
it's not
all.
enough for you simply to write an article and put out on whatever kind of podcasts or whatever things you have, saying that you are a completely legitimate organization concerned with the welfare of police departments, raising money for that purpose, etc.
I mean, how long do these known defamations have to continue?
Well, on
When
the
somebody-
internet, there are all sorts of things. I mean, I can see like a flood of lawsuits against Fox News, for example, or anybody who takes positions on matters of controversy in today's world.
Well, I'm not changing all the rules of defamation. What we're talking about
Yes,
here.
you are, I think.
No, I'm not. The only issue that is different is when does the cause of action arise? In the normal case, it arises upon publication. Under subsection 2, it arises when the defamer knows that they are publishing a false and defamatory statement.
Mr.
And all they
Bob,
have to do is stop.
Mr. Bob,
That's it.
do you acknowledge you might have a dispute here with Gannett because you view their responses as retractions. They don't view their responses as retractions. I think that's a big stumbling block here.
Yeah, they don't have a duty to retract, and 5772 does not impose a duty to retract. It just imposes, it says it right there, remove defamatory material.
But it's been
That's it.
understood as adoption of somebody else's defamatory statement, not your own, because one's own defamatory statement is covered by one.
Well, but why wouldn't it be covered by 2? There's
Because
nothing
it's
in 2.
redundant. We don't expect that.
Well,
sort of
there's
thing.
nothing in the wording of 2 that says anything about the originator of
I'm
it.
just saying, reading it as a whole and looking at the comments and so on. I just
Well-
want to alert you, Mr. Bob, you're running out of time if you want to save something for rebuttal.
I do. Thank you.
Certainly. Mr. Eaton.
Good morning, Your Honors. Tim Eaton on behalf of the defendants, appellees. Your Honor, I'm going to go right to Section 577 first because there's been several questions about it, and I would like to clarify, make certain our position is known. Judge Wood, your question is right on point. Why would you have number 2 when number 1 talks about what constitutes publication when the person who made the publication is identified? Number 2 deals with adopting someone else's defamation. For example, in number 2, the literal language says one who intentionally and unreasonably fails to remove defamatory matter that he knows to be exhibited. Well, if he put the defamatory material on the website, he obviously knew. Why would there be a requirement of knowledge if that's the person who's doing the defamation? So,
But you do agree, do you not, Mr. Eaton, that it doesn't say in so many words in number 2 that this is about failing to remove allegedly defamatory material that somebody else has uttered?
It does not, but I believe it's clarified in comment P and also in the illustration that's given, Your Honor. And in the district court, counsel said, our position is based upon 577-2 and Tackett. And if you look at the comment P, which does deal with 577-2, it is talking about, they draw an analogy to section 362, C, the duty to use reasonable care to remedy a condition upon the defendant's land created by another. And the illustration that they give, which deals with the men's washroom and some scandalous statement about someone else, they said that if it can be adopted if they become aware of it and they don't take it down once they know it's defamatory, but it's someone else's statement. Tackett itself said exactly that situation. The individual, there were 2 signs put up in the company where he worked. One was a small sign that had been up there for 3 days, and this court said, well, that's not enough time. There's given notice. How could they determine to take it down? One had been up 7 or 8 months, and they said, well, that's kind of a, there's not enough information here to know whether that was reasonable to take it down because there's a reasonable requirement. But they also said, in the context of adopting a publication, that they believe the Indiana Supreme Court would adopt 577-2 as it relates to someone else's defamatory information. So that's to rely upon 577-2 in its comment and its illustration and Tackett for this new continued publication rule simply makes no sense. And we also believe the reason why no other case is out there, with the exception of the district court case that he cited in South Carolina. In that case, the district court judge said that he didn't believe that South Carolina would adopt a single publication rule. In all those states where there is the single publication rule, 577-2 has not reared its head in any type of continued publication rule. And I think the reason is, as this court noted in Pippin, that they thought the internet should be included in the single publication rule, and that's what we're talking about here, things that remain online, because if it wasn't, it would eviscerate the statute of limitations and expose online publishers to potentially limitless liability. And Judge Lee, that's exactly the point you were asking about. If, for example, there had been an initial lawsuit regarding the first publication, and we were successful because they were unable to prove actual malice, which would be required in this instance. And then 3 or 4 years later, there's someone that maybe recants their testimony or a new fact becomes evident and they put us on notice. We then have to investigate again what happened. And then we would be exposed, if we didn't correct or remove, to another lawsuit. That could happen again 3 or 4 years down the road. It could be endless liability. And
So,
I think,
Mr. Eaton, though,
yes.
I mean, you have this parade of horribles. Mr. Bob pushes back and says, no, there would be some way of saying that you have one and only one opportunity to show that the previously acceptable statement has become defamatory because of now, let's say, whether it's NPA's proof that they're a legit organization or whether it's, whatever the hypothetical you want. Is the problem that this is just a lot of detail for a state Supreme Court to adopt? I mean, some sort of confining this to one and only one opportunity to point out that this is a mistake. Is this even responsive to the problem of all this garbage that sits around in the internet forever and ever and, is constantly being picked up by browser searches and the like?
Your Honor, there's no question that certain policy decisions would have to be made by the Supreme Court of Indiana to put some parameters on this. For example, Professor Volok says in his article, well, it could result in you having to do an investigation every time this issue comes up. And so he would limit the statute of limitations to 2 years. That's not what the MPA appellant's position is.
Right.
They think it should be able to go on forever. The other issue is, well, how long do they have to investigate before the statute of limitations is triggered? I think he proposes a statute that says 14 days. I mean, clearly it seems to me this is a weighing of benefits and burdens with respect to things that are online, which is obviously very prevalent now. And it more than likely should be a legislative decision as to weighing those burdens and benefits. And I think that's why the professor proposed a statute that could be argued about. But certainly the Indiana Supreme Court, there's been no indication, as Your Honor pointed out, that they would be likely to adopt something like this if it's even a doubt. In fact, the one case which we cited that comes close, we admit it's not on all fours, is the Pack versus Truth Publishing case, which is a Court of Appeals decision in Indiana, where they said in the context of a anti-SLAPP summary judgment motion by a newspaper who was sued for defamation, they said in that case that if it appeared repeatedly, they did not think that the court would allow such a thing because there was only one publication should be actionable. And that's really what they were saying, which is very close to the single publication rule.
So if there
yes.
is no remedy under this continuous publication theory, what is a party in NPA's position supposed to do when I assume their ability to raise money is adversely affected by a slew of articles that call them a scam, and how do they remedy that?
Your Honor, I would like to say one thing before I address that specific question, because you related it to NPA. We did due diligence on some of the facts that they had challenged. First of all, the original article asked them for comment, which they gave. They said it's not a scam. They gave some good examples of where they had benefited a community or two. On the other hand, the only thing that was challenged was whether or not these cities involved were in sanctuary areas or sanctuary cities, and whether or not they were 501c3. That doesn't mean that it wasn't still a scam. As a matter of fact, in the lower court, we attached to our we attached to the motion to dismiss instances where we're still getting scam alerts from different cities. There were 6 more cities. And counsel says we continue to keep false information on our website. That's just not true. It was true that they are a scam, and we stuck with that position. And the other thing that
Can I say your reporting seemed to me to say that there was concern in the cities that they might be a scam. It was quoting various police officers. Are you admitting that you yourselves called them a scam?
No. What I was saying was, and you're right, I think the chief of police of Trenton said that.
Right.
I think there was one other city where Belle Isle, who was concerned about an elderly population who were receiving these fundraising letters, and he was concerned about taking advantage of them. And so the conclusion that they were a scam was based upon sources that we cited in the article and later scam alerts. The other thing is, how often can they come back with this information? For example, if they'd sued us originally regarding the first publication, I think they would have lost. They concede that there was no actual malice proven in that situation. So then they come back to us later with more information after the 2 years. They say, well, some of these places were in sanctuary areas or metropolitan areas that had sanctuary schools. So is that enough to withdraw? Could we be sued then if we didn't? They come back 3 years later, 4 years later with a new
Retract
fact.
or remove, I take it. You're not making a big deal about whether it's a retraction or a removal.
No. I think a retraction, as I understand it, would be a recanting of what we said.
Yeah, it's one of those
Removal,
little squibs, sorry, we got this wrong, it's really such and such.
it could be.
Yeah.
Or a correction. A correction, they're not sanctuary cities, but the officers still call them a scam. And by the way, the officers, at least in 2 instances that withdrew that characterization after they were sued. And so, and we had an article about that as well. I think the precedent that this court either would set, which I doubt you would do, based upon a reluctance, understandable reluctance to predict with all these various issues what Indiana would do, and Indiana has given no indication at all that they would adopt a rule like this, particularly 577. Here you have a district court in Indiana that did not believe that they would change. You have a decision in 2021 from this court in the Pack versus Middlebury case, which again talked about a press release that had preceded a settlement agreement, and then people could go online and read the original press release. And this court basically was saying that they thought Indiana would not find there would be an actionable lawsuit for something that had been written earlier, and then the after the fact information came to the company that had put it on the website. So I think every indication is that the Indiana Supreme Court would adopt the single publication rule. And there's not been one case where the single publication rule has been in effect where this continued publication rule has been in place. And again, and at the risk of repeating myself, I think the issue would be, it would be a very uncertain statute of limitations because you wouldn't know exactly when it would run. It's an easy statute of limitations right now in Indiana. It's the date of publication. And here, I think counsel's arguing in their briefs that it would be the mens rea in terms of when actual malice occurred, which is not as easily determined. So there could be a very loose statute of limitations. There could be multiple lawsuits that could arise. And more importantly, as it was pointed out in the amicus brief that was signed by 40 different news organizations, the burden of having to investigate every single time this comes in with no temporal limitation, which is
not just no temporal limitation. I mean, the degree, it's very easy to say you've been notified that there was a mistake, and if it's, this was the wrong Tim Eaton or something,
right,
then you know. But there are bound to be quite a few situations in which the question whether there was a mistake isn't crystal clear.
That's absolutely true. And the longer you go, Your Honor, for example, the reporter may no longer be with the newspaper, may have passed away if it's 40 years later. How can you investigate those type of materials and at the risk of being sued again, or the risk of being sued for the first time when your original publication was truthful? And so that's the dilemma, and I don't see no indication, because I think, as this court asked earlier, not one case in this country has adopted it. There's a district court case, again in South Carolina, where the district court determined South Carolina would not follow the single publication rule, and yet there was a subsequent South Carolina state court case that said they would, and they would follow the single publication rule. So he hasn't really pointed to a case on point that he's asking this court to adopt out of whole cloth with all these various elements that would have to be decided. And I think that would not be an appropriate use of the certification because, again, there's no indication here that the law is unsettled. So we respectfully ask that this court affirm the decision of the district court and not certify to the Indiana Supreme Court. Thank you.
All right, thank you very much. Anything further, Mr. Bauer?
Yes, Your Honor, thank you. The single argument about the single publication rule is just a huge red herring. It applies whether the action accrues on publication, which is the normal case. It applies if the action arises because under subsection 2, the defamer now knows that the statements they are making are false. The question always is under
to what degree of certainty does the alleged defamer need to know that?
Well, the standard is intentionally and unreasonably. In other words, they have to not remove if they do so intentionally and unreasonably.
But do
and
they
that
have
would
to
include,
be positive that it was a mistake? Does it seem more likely than not it was a mistake? I mean, think of your own fact situation where there are questions about the organization, and it's certainly true that some people have said negative things about it, but how clear does it need to be?
Well, civil cases are, preponderance of the evidence. I don't know why
I
they should
understand
be.
that. So if you think it's more likely than not that you made a mistake, then you have this burden to
No, more
delete from your website.
No, more likely than not, than you're making a false statement that defames somebody. And that you want, and of course, and that it would be, and when you're talking about internet, it's very, there's a balancing under this test, and it's very, easy to correct, and the harm is enormous. I mean, it goes on forever, access to millions and billions of people.
Okay.
So, that can be readily fixed, and I see
All
my
right.
time is up.
Thank you very much.
Thank you.
Thanks to both counsel. We will take the case under advisement. All right, our third case for this morning is United States ex rel. Calderon against Carrington Mortgage Services, LLC, 22-15-53. And we will hear both from the appellants and from the government first, and then we will hear from the appellee. So I'm not sure what order you want to go in. Are you Ms. Blackwell?
Yes, ma'am.
All right, you may proceed.
Your Honor, may it please the court, Jennifer Blackwell on behalf of appellant plaintiff Michelle Calderon as relator on behalf of the United States of America. The district court committed reversible error on 3 key determinations. This case comes down to one focal point. Carrington Mortgage Company's entire purpose in the FHA HUD program is as gatekeeper, as a fiduciary of HUD, to verify the creditworthiness of potential borrowers for FHA insured loans. Misrepresenting that creditworthiness in and of itself is prima facie evidence of both materiality under Universal Healthcare versus Escobar and of causation under United States versus Luce.
So, Ms. Blackwell,
Yes.
as I understand it, the parties go in some length with regard to the post-endorsement technical review that is conducted by HUD. And as I understand it, approximately 71 or so of the loans at issue went through that process, and HUD decided, you know what, we're going to pay the insurance claim. With regard to those 71 loans, is there any dispute that whatever deficiencies there were, that they were immaterial because HUD didn't think it really mattered to their payment decision and they paid?
Yes, Your Honor, there is a very large dispute in that regard. With regard to those 71 files, there is no indication with regard to what HUD looked at in those files and whether those deficiencies found by HUD corresponded with the deficiencies found by relator in this case to present as fraud. There's no specific indication as to whether HUD found inflated income, omitted debt, or other fraudulent submissions in those files that directly correspond to what relator found and wants to present to a jury in this case. Because
So are you drawing a distinction between what HUD is doing at the moment it makes the decision to insure versus what HUD is doing when presented with a claim for payment on the insurance benefits?
And Your Honor, that is a very good point. This case is focal on the creditworthiness of the borrowers.
The upfront decision.
The
basically.
upfront
Should we
decision.
insure?
The implied false certification at the moment of claim is Carrington saying to HUD, we want you to pay this claim on this failed loan. And they are implying that all regulations were met in assessing and certifying that loan. That is where the fraud occurred. The fraud occurs up front, and the actionable claim occurs, the action occurs when the claim is made later with HUD to obtain the funding. And that's the distinction. And Judge Lee, the Peters that are done later in the process, you know, a lot of this post-endorsement activity and the evidence that follows, for instance, the HUD letters to Carrington that we discuss, the reasons for default that we discuss, that's all icing on the cake. The focal point here is that Carrington is the gatekeeper of the creditworthiness of these borrowers. And it's a key point that is made in...
But I guess, counsel, I understand that theory. What I'm struggling with is trying to connect the alleged deficiencies in the initial underwriting submissions to the issue of whether or not HUD believes that those deficiencies are in any way material.
Understood, Your Honor. And I think if we look at Escobar, the question is answered. In Escobar,
Before you talk about Escobar, it would help me if you, in answering Judge Lee's question, if you could just tick off, you know, kind of almost bullet points, the what you think the best evidence in the record is that would allow you to get over a summary judgment on this, whether it's the HUD letters or whether it's the what is it that tells us that these problems are material to HUD?
and Your Honor, I think perhaps the Escobar quote goes directly to that, and I will follow up. In Escobar, the court found that Universal Health misrepresented its compliance with mental health facility requirements that are so central to the provision of mental health counseling that the Medicaid program would not have paid the claims had it known the violations. The creditworthiness of the borrowers is the entire gatekeeping purpose of Carrington. And if Carrington misrepresents that creditworthiness on the front end of the certification, then that defeats its entire gatekeeping purpose and its fiduciary responsibility to HUD. And if, you know, as additional evidence, the HUD letters to Carrington specifically laid out inflated income, we're not going to pay it. Omitted debt, we're not going to pay it. They had actual knowledge from HUD that these were material violations. And those specific types of violations are exactly what Relator found in the files that she reviewed and that we submitted with the summary judgment argument. Do I have 1 minute left total?
The total, yes.
Okay,
if you would
then
like
I
to
need
sit
to
down.
reserve.
All right, that's fine. Ms. Utrecht.
Good morning, Your Honors. Jennifer Utrecht on behalf of the government. I'd like to begin by reiterating the point that the central inquiry on materiality is whether the false certification has a tendency to influence the government's payment decision. And here we're dealing with a situation in which the decision to make payment happens when the government endorses the loan. By endorsing the loan, the government agrees that in the event of a default, the government is going to pay. And that is uncontestable by statute. It has to make that payment decision.
So isn't this just basically, once they've made that agreement at that moment that you're describing, if there's a later default on the mortgage, you know, HUD just happened to make a bad deal. So they have to pay anyway and maybe revise their underwriting criteria next time. I'm trying to like follow through on the idea that the back end payment is a mechanical, you know, just automatic consequence of the front end decision to insure the loan.
Yes, Your Honor, that's correct. Once the front end decision is made, payment issues. So the relevant question for materiality is whether the certification, and there's, you know, a loan specific certification that has to be signed by every lender, that the borrower in fact complies with the incoming credit requirements under HUD's underwriting.
And that's the implied false certification when the lender says to HUD, this buyer looks good to us?
Well, it would be an express false certification in that case, because there's actually a document that has been signed that HUD requires every lender to sign. And you know, that The fact that HUD requires every lender to sign it only underscores how important this is to the overall functioning of the direct endorsement program.
So is the government's position then in the context of this program that any and every violation of the underwriting guidelines are by definition material?
Well, Your Honor, I think we should rephrase that inquiry slightly. The question is whether the false certification that the borrower meets the income and credit requirements, whether
the certification is that they've met all of the underwriting criteria, right?
That it meets the income and credit requirements under the underwriting guidelines.
And so
yes.
if that certification is inaccurate, even as to one particular underwriting requirement, whatever that might be, is it the government's position that that per se makes it material? Because that seems like that seems very much to go against what the language of Escobar and kind of.
Well, Your Honor, I think what our position is, and as we lay out in our brief, what Escobar says, and of course, Escobar was a case about implied certifications where there wasn't actually a document that had been signed by someone saying that this is, a significant requirement. You must sign this for us to issue any sort of payment. So, in some sense, this is a much easier case than Escobar because there's an express certification. But what Escobar says is that we're supposed to be looking to whether there's a natural tendency to influence the payment decision. And so the real question here is, if this certification had not been made, if no one had said this borrower meets the eligibility requirements, would the government have agreed to endorse the loan? And the answer to that is fairly self-evident. The government, of course, is not going to agree to endorse a loan if it knows that the borrower does not meet the income and credit worthiness requirements under the underwriting guidelines.
You keep saying income and credit. So is there a separate sentence in the certification that focuses on that? Or I think what Judge Lee is getting at is, I believe the court's understanding in Escobar that there are some regulations that are just nitpicky, use 8.5 by 11 paper, and other requirements that deal just with the heart of the transaction.
Well, Your Honor, the reason I keep using that phrase is I believe the form F2900A at the time of the relevant inquiry did use those terms.
Okay. That's good.
But also, there's an annual certification that must be made that you comply with all underwriting requirements. But the reason I keep emphasizing credit and income is because more so than we believe all the underwriting requirements are a significant part of this program, but those are central to the overall functioning. If a borrower does not actually meet the level of risk the government is willing to assume, the government is of course not going to endorse that loan. And that point is also illustrated by the government actions that were taken after the endorsement that were highlighted by the district court. So the Peter process, this post-endorsement technical review, looks to whether there are any deficiencies in the underwriting process and when the deficiencies actually would render the borrower ineligible. So, for example, if there's a minimum amount of assets the borrower must have, and there's not a documentation that shows that the borrower meets that minimum, that sort of thing is the kind of extreme significant deficiency that HUD will go on to say to the lender, we're engaged in this audit process because we're trying to improve in the future so we don't endorse loans that have any deficiencies, but this kind of deficiency is so significant that we are requesting that you indemnify us. And that shows...
So is there ever an occasion where HUD looks at deficiency and says, you know what, we don't really care? So the income is, it's stated to be $25,000, but it's actually $23,000. It violates the guidelines and the accuracy, but you know what? It's not going to impact our decision or our decision to pay the claim.
So...
Would that be probative of materiality?
A couple of responses, Your Honor.
Can you answer my last question first?
Yes. Last question first being, would that be probative? Escobar establishes the government action is probative of materiality. I would posit, that where Escobar is looking at the government's knowledge and the government's actions before the decision to make the claim. And of course, everything that's happening in the post-endorsement process is happening after the decision has been made. The post-endorsement process doesn't cover every loan. It only covers a small sample. And also, I'm sorry. Yes, please. I want to make sure that I get to your question about are there sort of insignificant violations, but please.
No, absolutely. I think perhaps my question was a bit inartful, and perhaps what I'm really trying to get at is what the plaintiff would need to show to meet their burden of materiality in a case in this program. Does the plaintiff need to show any facts with regard to materiality then, other than to show that a particular that there were a particular certification was inaccurate as to one or more conditions of payment.
So in this case, we think that this particular certification, and of course there are many certifications that are made in the course of the mortgage insurance program. Luce involved a very different type of certification that involved which lenders were eligible to participate in the program at all. And even there, this court held that certification was of fundamental importance despite post-government action happening after the endorsement had already been made. Of course, and so here, we think this is an even easier case. You look, the relator has to show that this certification is material to the government's decision to pay. Is it an express condition under Escobar? Is it the kind of thing that goes to the essence of the bargain? And the answer to all of those questions is yes. And of course, the government's action in this post-endorsement review can be relative, or it can be probative, but it's not dispositive. And as we've outlined in our brief, and as I hope I've illustrated here today, the actions that the government took with respect to these loans only supports a finding that this certification is truly material and truly important to the government's agreement to endorse these loans.
Okay, I think you're out of time, so thank you very much. Mr. Bullock.
Good morning, Your Honors. Hank Bullock on behalf of the appellee Carrington Mortgage Services. May it please the court, the district court properly granted summary judgment in this case. Relator had an affirmative burden to present evidence of materiality and causation with respect to each of the loans that she claims presented a false claim.
So we had this big debate in the briefs about whether this was going to be a loan-by-loan process or whether it was going to be kind of up 10,000 feet, a statistical analysis. And Carrington seems to have gone back and forth. So are you now on the loan-by-loan theory?
Your Honor, I don't think we've ever been back and forth. I think the parties argued loan by loan in the district court. Judge Young issued a ruling in February of 2020 on that issue. The relator has never appealed it. We moved for summary judgment, arguing that she could not across the board on any loan show materiality or causation.
So if we could find a single loan on which she has shown materiality and causation, that would require reversal then.
I don't know that that is true, but I also don't know that she can present a single loan on which she's done that. And I want to step back here. Many of the questions that Judge Lee, you asked, many of the questions that you asked Judge Wood, went to what is the evidence in this case? How do we look at what has been presented? And everything that the relator and the government said was on a theoretical level, not on an actual level. And I think we have to revert back to what this case is. This is summary judgment. There are 4 elements to the claim: falsity, scienter, materiality, causation. The relator openly said today, we're going to collapse them all into one. The minute you make a false statement,
they didn't quite say that. I mean, the materiality, the focus has been on materiality and causation, those 2 elements. And of the 2, at least the government certainly focused more on materiality. I think materiality is a perfectly acceptable starting point. I was interested that you didn't have much to say about the letters that HUD sent.
I think our briefs did say something about the letters, and I'm happy to do so here. Those letters refer to 8 loans discussing deficiencies that HUD in the letters characterized as material. Now, as the record makes clear, first point right out of the box, 7 of those letters were ultimately approved by HUD. So whatever was said in the initial letter...
But with some kind of correction? There was a possibility of modifications?
Every loan goes through a process, an extensive process with HUD, where if HUD raises questions, you have the right to mitigate it.
Right.
Carrington mitigated whatever deficiencies were allegedly material.
It doesn't mean the original deficiencies weren't material. It means you had to do something about it.
That is true. But what also is the case among those letters is that different loans have the same issue as material and not. And I want to go to a question Judge Lee asked. What do we make of the 71 loans that went through the Peter process? There was a very clear question posed to the government. Are you saying that there are no minor deficiencies about which HUD doesn't care? That question was completely avoided. And I think if we go to the regulations on the Peter process, the answer is clear. HUD says there are 4 categories of loan in the Peter. There's conforming. It's crystal clear. It's beautiful. It is pristine. There's deficient. It has underwriting defects. but it still is an acceptable credit risk to HUD that they are willing to insure. There's unacceptable, which is on this record we won't insure it, and there's mitigated, which is you've explained to us why there's not a problem.
So where do the loans fit in? I certainly remember from reading briefs that there are loans where HUD went back to Carrington, probably to other people in the program too, and said, we've reviewed this. This is a bad loan. You now are going to have to indemnify. If the day comes that we have to pay a claim on this loan, we're going to turn to you to make us whole. In a sense, shifting that payment over to Carrington. That strikes me as something where the flaw was material, where the government took steps to avoid loss to itself.
Notably, though, Your Honor,
it was just a sample. So there must be other loans in the program that didn't get caught.
Two things. One, that one loan where indemnification was required, that's never defaulted and it's not a loan at issue in this case. And second, again, I come back to it's the relator's burden at summary judgment to present evidence.
Why does that mean that it's not material if HUD insisted that you stand behind it?
Because HUD says each loan is reviewed individually and separately when it reviews loans. And HUD goes through the Peter process, which here it did 71 of 270. So more than 1 in, what is that? That's almost 1 in 4 loans was re-reviewed by HUD, and some had defects, some didn't, and they said they're all good, we agree to insure them, they are properly insured. HUD's guidelines say no one underwriting defect is dispositive. You look at the circumstances surrounding each individual loan to determine whether it is an acceptable credit risk. Relator doesn't go through any of these loans in this case that are at issue and say, here's what HUD thinks about these loans. Here's why HUD in this instance would find this material. That is her burden, and the district court went through a long list of things she could have done. Every one of the cases that the government or the relator cites in their brief at summary judgment on materiality is instructive. It involves some form of affirmative evidence from the government or the relator showing what the government believes. Government testimony, guilty pleas where materiality is conceded.
Right, but
none of that's present
before you
here.
get too carried away in this, let's look at a loan. So I looked at borrower 142, and there was an alleged misrepresentation that income was inflated. There's a code that reflects this. And obviously inflated income is material to a payment decision. If I tell you I'm earning $100,000 a year and I actually only earn 48, that strikes me as something that a lender would think quite material. And the Carrington itself has all these reason for default codes that indicate, whether it's excessive obligations or whether it's insufficient income or whatever it may be. So default's foreseeable, and then that loan happened to default at 7 months, and there are claims in the amount of $91,720. So why isn't that like an example of a loan that there was a misrepresentation, it was a material misrepresentation, it caused the government to pay out money that it shouldn't have had to pay out?
I would say there are 2 reasons, and they go together, and one is one that hasn't been discussed here. But the first is there's no evidence. The court is supposed to look at what would change HUD's mind. And in all the cases that they cite, there's actual evidence about HUD's priorities, HUD's views. The agency might testify, there might be actions showing disbarment, disciplinary action. There's none of that here. That was relator's burden. She had to bring that forward at summary judgment. She chose not to. Instead, she tried to shortcut the process. She designated herself as an expert essentially to testify on all 4 elements of her claim.
So she designates herself as kind of an in-house expert, not the kind who has to prepare a report under 24.
Correct.
Correct.
And we don't dispute the non-retained expert nature that she doesn't need a report, but that doesn't obviate the need to satisfy the requirements of Rule 702 in Daubert, which as a threshold, I heard a lot about gatekeeping earlier. If we want to talk about gatekeeping, experience and qualification. In her later gave 2 depositions, and in those depositions, she made concession after concession about her lack of experience outside of the underwriting world.
So what's interesting is I see a disconnect between what she was saying in the district court and what she's saying now, because I think what she's saying now is I had personal experience of going through loans where the income was inflated, where these sorts of things. In the district court, she seems to be talking about what Carrington was doing, things that maybe dealt with departments that she wasn't part of, I think it's a couple of different things.
Exactly, Your Honor. All of her proposed proffered evidence on these issues would come as an expert because she never worked in those areas, and she acknowledged that she didn't have the experience there, and the district court properly excluded that testimony.
But wouldn't you agree that she could have testified about loans that she reviewed?
She could have testified about the underwriting of the loans she reviewed. I absolutely agree with that, and if you look at our papers on the court below, we never disputed that. What we disputed is she can't substitute her own judgment for that of HUD. She can't substitute her own judgment for someone who then tracked the loan from the point of insurance and closing all the way through default. She has no basis. There's nothing she can offer to the jury that would assist it in any way, no genuine fact that she can provide that explains one way or the other what the issue is here. She has, and the district court made that clear. There was a long list of failures of evidence, nothing that shows what HUD thinks or doesn't think on a loan-by-loan basis. And based on the HUD regulations that say no violation is dispositive.
She was trying to rely on, first of all, the HUD regulations' own definition of materiality, which I can't believe is immaterial.
Well, but I want to, that's an important point, and I'm glad you raised it. Let's look at that definition. The government cites it, she cites it. The definition says these things may be material. Again, it's not an across-the-board rule, which goes back to what's in the 4155. That's the HUD underwriting guidelines that were at issue at this time. No one defect is dispositive, and I come back to your question, Judge Lee. The government wouldn't answer that. You said point blank. Are you saying that every violation is material? Well, that's what the relator said in the district court. She changes her tune now, but that's effectively what the government said when it refused to answer your question. We know that's not the case. Why? The reg says may be material. It doesn't say will be. The Peter process itself, as set out in the guidelines, says no one defect results in an automatic characterization. And we know that 71 of the loans actually went through the Peter process. And I'm glad that I printed this out last night because your question goes to it. You asked Ms. Blackwell, what did the government look at in the HUD Peter process? Is there a dispute that those 71 loans are off the table? And she said, well, we don't know what they looked like at. Well, that's not true. If you look at section 4155.2, chapter 9, section B1A, HUD performs a post-endorsement technical review on selected cases to evaluate the risk that loans present to FHA's insurance funds and lenders' compliance with FHA's underwriting requirements and documentation requirements. Later, when conducting a Peter review, assess whether the loan represents an acceptable level of risk to the FHA insurance funds. Assess how well the underwriter arrived at their decisions, addressed inconsistencies and problems, made reasonable conclusions based on the information and documentation in the case, and complied with the FHA guidelines. Effectively, that's everything that the relator claims she did when she re-underwrote the loans. But here's the difference. She never worked at HUD. She doesn't know what HUD values or what HUD thinks important. She says based on her underwriting experience she does, but she's never communicated with them when they decide to make a payment or when they conduct a Peter. And that makes clear that all she's trying to do is substitute her judgment for theirs. She can't do that. She lacks the qualification, and without that, there's no evidence of materiality. I do want to, because I know
So you don't think anything is material, actually? I mean, so HUD could insure a loan where somebody's been, living on the streets for 6 months, not an asset to their name.
I don't think that's true, Your Honor. I think that there are things that very well may be material, but I think we need someone with knowledge and expertise and understanding to tell us that. And that was the relator's
And it's
burden.
not enough to look at both the HUD letters, it's not enough to look at the regulations, it's not enough to look at the loans with the codes showing failures.
I think when they don't set across-the-board guidelines, correct. And I think when they make clear that it's a judgment process at HUD, that's correct. But even if that were the case, that would only get the relator over one of the two humps she needs to surpass today. We haven't really talked about the causation issue, but there is literally, other than default codes that she offered at the last minute, there's no evidence in the record here. Now, the relator has made clear she never worked in loan servicing. That's the part of an originator or a company that tracks the loan once it's out there, collect the payments, discusses whether it needs to be modified,
Is
whether
that
it's
the right
refinanced.
level of causation, or are we looking at what prompted HUD to approve the loan for insurance to begin with?
I think if we look at the latter, that's but for causation, and I think you were on the panel in Luce, which made clear that's not enough. We need proximate cause here, and
You
what
need
that
both. I mean,
correct,
certainly a minimum,
correct,
you need
but
both.
we don't have the proximate cause here. And in that decision in Luce, this court cited the Hibbs decision, and I think that's instructive. Hibbs said, look, you can't just say the loan was insured under false pretenses. You have to show that that false pretense is what caused the government's loss, what
what
led to
drove
the
the-
default. There is nothing in the record here that in any way can explain that to the jury. Now, the relator points to these default codes, which she claims Carrington designated at the time of default. Let's be clear what those are. Those are 2 or 3 word codes that are from a drop-down menu that, without any explanation whatsoever, no one is going to be able to tell to the jury what those codes mean, when they're decided, when they're designated, or the like. And they're
Maybe
all-
not. I'm going to say
I
people in
hear
your
you.
position frequently defend boilerplate, but
Of
I'll
course,
allow you not to
but,
now.
But they're completely after the fact. And all that we would have with those codes is we'd give them to the jury, and people can say whatever they want with no one having qualification. She didn't ask any Carrington employees about this. She didn't ask HUD about this. She has no evidence. And again, the failure of evidence here, just the attempt to collapse all of these elements into one and obviate anything could not have been what this court required in Luce. Luce made clear you have to have something more. You have to have proximate cause. And they're simply skipping over that step and hoping that it will be ignored. Your Honors, we think that the district court's grant of summary judgment was proper. We respectfully request that you affirm, and unless there are any other questions, I would rest.
I see none, so thank you very much.
Thank you.
I think you had a very small amount of time, Ms. Blackwell, so.
Your Honors, I hear a lot of questions of fact for the jury. Judge Lee, no, not every violation of a guideline is material. But the loans laid out by relator are income, inflated income, omitted debt. This isn't the American-made stapler in Escobar. These are material violations that are relevant to the credit worthiness as to whether that borrower is going to be able to repay this loan, which should be in everyone's best interest.
So is it relevant? You mentioned income. Does it matter by how much the income was overstated or understated in your analysis, or just the fact that it was inaccurate? Is that enough?
Well, if it's overstated and there are 4 other issues with the loan and debt's deflated and there aren't verifications that are required, those things work in conjunction, and that's what relator put before the court in each and every one of these files. So maybe standing alone, no, but as a whole, with the problems with the loan, then yes. With regard to causation, there are cases on point that are cited. U.S. v. Emeritus Mortgage, U.S. v. Spicer, U.S. v. Peterson. Even with no additional evidence of causation, the fact that false certifications with inflated income, omitted debt, and related, etc., related directly to the soundness of the loans and the creditworthiness of the borrowers. The lower court was incorrect in granting summary judgment because under Luce, that creditworthiness goes directly to causation, which has been applied across this country in lower courts and in district courts.
Okay, thank you very much.
Thank you, Your Honor.
Thanks to all counsel. The court will take the case under advisement. Case number 4 for this morning's calendar, Cooey against Garland, 22-2177, is going to be submitted on the briefs. And so we will move directly to case number 5, Jones against Teagles, number 22-2084. Mr. Malkus.
Good morning, and may it please the court. My name is David Malkus, and I'm appearing on behalf of Johnny Jones. Supreme Court case law holds that courts must give a broad rather than narrow interpretation to a defendant's request for counsel, and further that courts must evaluate such requests as ordinary people would understand them. The state court decision here unreasonably applied this precedent because no ambiguity surrounded the plain language that Mr. Jones used. When Mr. Jones said, "So y'all can get a public pretender right now," a reasonable listener would understand that he wanted an attorney. Additionally,
Why is, I mean, given the deferential standard that we are obliged to apply here, for starters, there is no such job as a public pretender. You know, it could be seen as wry wit or something, even if people weren't laughing. I mean, I know you can listen to the recording, and maybe there was general laughter, maybe not, but I just don't know why it's so far outside the realm of how that exchange could be understood to permit us to find that the standards of EDPA have been met.
well, first, public defender is a term that's commonly used by public defender clients, as I
Pretender is
yeah,
used?
pretender is,
Okay.
yes. And I think it's also important that the detectives here, in fact, understood that Mr. Jones was asking for a public defender. When Mr. Jones said that he wanted a pretender, detectives told him that they're actually called public defenders. Mr. Jones confirmed that that's what he was referring to, and detectives told Mr. Jones that they could not provide a public defender for him.
Can I pause on that? You are not, as I understand it, making any argument that he asked for counsel but was inappropriately turned down. I mean, we have the detective saying, after he says, oh yeah, the detective says, we obviously, due to the time right now, we can't, you know, a little bit of a pause. So you could read that as saying, we're not going to get you a lawyer, even though you have asked for one, but I do not see you making that argument exactly in your briefs.
I do believe that the detectives were telling Mr. Jones that they were not going to provide him a public defender based on the time of night, that Mr. Jones had asked for a public defender. Detectives understood what he was asking for and basically said it was not possible for them to honor that request.
I mean, that would be an independent Fifth Amendment violation. It wouldn't just be a Miranda kind of problem.
Yes, that's true. My briefs focus on essentially that when Mr. Jones asks for a public pretender, again, a reasonable listener would understand what he was asking for at that point, based on the fact that public defenders are commonly referred to as public pretenders by their own clients. And so I think that the plain language that he used made his request clear to the officers. The officers understood that, and the questioning did not end at that point, and that forms the basis for the Miranda violation.
So what about the fact that literally seconds after the detective answers, as I just said, Mr. Jones just jumps, he reinitiates discussion, I'll put it that way, jumps right back into the conversation, says, how much time do you face from reckless homicide?
Yes, he asks that single question, and in my review of the audio recording, the detectives tell Mr. Jones that they cannot honor his request for a public defender, and then there's a pause for about 5 to 6 seconds before Mr. Jones asks for or asks the question about prison exposure. So I think that pause is of some significance as well, because it's not a situation where Mr. Jones immediately leaps into another question where he's indicating that he just wants to continue on with the interrogation. It's a situation where detectives are telling Mr. Jones that he cannot have a public defender. They're not ending the interrogation at that point, and instead they're just sitting there in awkward silence waiting for him to say something, and then once he does, they answer the question, and they continue on with their questions of him.
Which he doesn't object to. I mean, I'm just wondering, there's the first question, which is whether he actually invoked his right to counsel unambiguously enough that we could actually say there was it was an unreasonable application of clearly established Supreme Court law for the Wisconsin courts not to see it that way. So that's the first question. Even if he did ask for a lawyer, it is certainly possible, and the Supreme Court has held this, in situations where somebody reinitiates the discussion, you've waived that.
In certain circumstances, yes, Your Honor, that's correct. I don't believe that that is the case in this situation where Mr. Jones asks one single question about his exposure to prison after a 5 to 6 second pause when he's been refused counsel. I don't think that that would qualify as a waiver under the Smith case that I cited in my brief, in which the court talks about how there can be waiver in certain circumstances, but it has to be not just a suspect reinitiating, but it has to be, in addition to that, a knowing and voluntary and intelligent waiver. I don't think that there's any basis for that in this record, and that's not an argument that the respondent has made at any stage in this case. So I don't think there's enough to find that this was a knowing and intelligent and voluntary waiver of his right to counsel just by asking a single question about prison.
I'm trying to understand, going back to the unambiguous invocation, what your best case is that the question he asks, and I'm just going to state it as if he asked for a public defender, so y'all can get a public defender right now, that's unambiguous, because you've got Davis, which says when you include that kind of equivocation language or signals like the word maybe or a question mark, that is not unambiguous. What case do you have that says the contrary, Supreme Court case, or are you merely relying on the broader precepts we have that say you must interpret these things broadly, so forth, so on?
Yes, Your Honor, I'm relying on those broader precepts. I don't believe that there's a case with identical facts, and I understand that that would be a separate basis for habeas relief if there was a case with identical facts in the Supreme Court with a different holding. But my argument here is that when he said, so y'all can get a public pretender right now, a reasonable listener would understand that he was asking for an attorney, and in particular, the words can and right now are in stark contrast to the language that was used in the Davis case that you cited, where the suspect, the defendant, is stating, maybe I should talk to a lawyer, whereas those words do suggest some level of ambiguity. The words can and right now are more decisive. I believe that this court, in several cases that I cited in my brief, has held that the word can, by definition, is more decisive and shows that a suspect had a present sense desire to consult with counsel. And so I understand that that's not Supreme Court case law, but I think the reasoning of those cases is no less applicable or no less true in this case. And I do see that I have about 90 seconds.
If you'd like to reserve.
I would.
Unless. Okay.
Thank you.
Let me do that. Mr. Held.
Thank you, Your Honor. I'm Assistant Attorney General Elliot Held on behalf of the respondent, Warden Lizzie Teagles. May it please the court, Mr. Jones is asking for a remedy reserved for extreme malfunctions in state criminal justice systems, and he's asking for that remedy where no constitutional violation occurred and where the state court reasonably determined under the totality of the circumstances that even the prophylactic Miranda rule was not violated. The ruling was reasonable under Davis v. U.S. because the public pretender comment only indicated at most that he might want an attorney.
So you think he needed to say, so y'all can get a public pretender right now, comma, and I want you to do that, period?
That would certainly give him a better argument, Your Honor. He doesn't necessarily have to say those exact words. But I think the public pretender comment, first, whether or not he was one of the folks who was laughing on the tape, I don't think it's clear error under 2254E1 that he wasn't. But even if this court thinks that that was clear error, public pretender is in itself objectively, a reasonable officer would objectively perceive that as a joke. They laughed in this case. That doesn't prove that it's objectively a joke, but I think it's objectively a joke, and it indicates.
But the detectives cleared that up, right? I mean, to the extent that they had any sort of misunderstanding, it seemed like certainly in the statements that followed that Detective Hensley obviously knew what he was talking about.
Yes, Judge Lee, they certainly understood that he meant public defender when he said public pretender. However, the question, of course, is whether he was unambiguously requesting one or not, or whether he was still making up his mind. And in this case, it was a question, and they admit in their reply brief, page 5, that it was said in the form of a question. So y'all can get a public pretender right now. And right now, they argue favors them. I would argue that right now favors us, because this was said at 1:47 a.m. in the morning. If you look at the record, the interrogation started at 1:18. Miranda was read beginning. 29 minutes in, they say this, it's 2 in the morning, and they laugh and they say, no, obviously, because of the time right now, we can't. And then, of course, there's a short pause, and then he asks the question, how much time is it anyway? You face off reckless homicide. The state court reasonably considered that follow-up question by Mr. Jones under Smith v. Illinois, because not only was it not in response to further interrogation, it wasn't in response to anything. He just interjected that as Judge
Well, let me ask you about that. Why was it not in response to being told he wasn't going to be given a lawyer? So then he asked the detectives the very question he would have asked a lawyer, a very reasonable question for a lawyer, had he been given one. He pauses 5 or 6 seconds. It's very clear he's not going to be given a lawyer. So he asked the one burning question he has for a lawyer right now to the detectives.
Right. So it's not interrogation first, I would say, because of course Rhode Island v. Innis, it has to be a statement that's reasonably, would be expected to elicit an incriminating response. And they just say no because of the time we don't have a lawyer. It's not a question or, give us your story or something like that. It is in response. You could argue that it's in response to something that they said, but there's no Supreme Court case law that indicates that anything that he says after something that one of the detectives says can't be used in the ambiguity assessment. It's only
but it is troublesome because he's told, in effect, it's the middle of the night, we're not going to get you a lawyer right now, which isn't the right answer, under Miranda. They have to say, you've now asked for a lawyer, it may take a little while, but we're going to get you one. And so just adjourn the questioning, everybody goes off and takes a nap, and then the lawyer shows up at 6 in the morning whenever the lawyer comes. So that's not what happens, which is what should have happened.
Well, under Davis, of course, it's the detective's risk to take if they think that it was an ambiguous invocation in this case. So they didn't ask him, they didn't immediately interrogate him. They just told him that, of course, due to I think the exact quote it's in here is, we obviously, due to the time right now, we can't. And then there's a few seconds, and then he asks how much time he's facing, and then it continues. They would, under Davis, of course, they would have been permitted to ask clarifying questions, and maybe it would have been ideal if they did that, but it's their risk to take if they don't want to, if they think it's ambiguous. And they are allowed to consider things that he says later, as long as it's not in response to interrogation, in determining whether his invocation was ambiguous. And this statement that he makes about how much time he's facing shows that his invocation was ambiguous, because it shows that he's still making up his mind. How much time?
The case law asks us to not focus on these post-interrogation responses, and detectives can consider what he says later. Aren't we permitted, however, to consider what happens before? And leading up to this exchange, there's a lot of space where Mr. Jones is not talking. And the detectives say, we invite you to talk. We want to hear your story. He's not saying anything. And then they say, okay, how do you want to proceed? Do you want to just hear us out? And he says, I'll hear you out. So he takes he goes through great pains not to make a statement. And so aren't we permitted to consider that when we get to this moment where he finally does make a statement after being given incorrect information?
You're permitted to consider the totality of the circumstances, Your Honor. It's the totality of the circumstances test under Davis, and under this court's ruling in Dassey v. Dittman, this court noted, and the Supreme Court says it in Yarborough, that the state courts get great leeway in their application of a totality of the circumstances type test under AEDPA. And AEDPA, of course, gives them great leeway to begin with, but especially when you have a totality of the circumstances. So you can consider what he said before, you can consider what he said after, as long as it's not in response to an interrogation, which his asking about how much time he was facing wasn't. You can consider that when he said, so y'all can give me a public pretender right now, that he was asking about essentially the immediate availability of a public pretender at 1:47 a.m. in the morning, which is a circumstance. So yes, Your Honor, you can consider the totality of the circumstances.
Now, how do we not have an unreasonable determination of fact here? This is separate from the unambiguous invocation question. where we have two courts who said he clearly was joking when he said public pretender. And then we listen to the recording, and so far as I don't hear a hint of merriment in his voice. And then we have two courts that say, and clearly 3 people were laughing after he made this joke. And I listened to the recording, and I can't tell how many people were laughing, much less whether one of them was Mr. Jones. So how do we not have an unreasonable determination of fact here in your view?
For a couple of reasons, Your Honor. First, as far as who's laughing, the court that said that I definitely, to my ears, he's laughing, that was the trial court at the hearing. And the trial court, remember, they heard Mr. Jones testify in its courtroom and heard the detectives testify in the courtroom. So it's familiar with the voices, and then it listened to the recording. And then the Court of Appeals said, well, we can't say that it's clearly erroneous. You know, there's at least one person laughing, and probably 2 or 3. And they said we can't find that it's clearly erroneous. So I don't think we can find that it's clearly erroneous. Just because if I can't tell exactly who's laughing, that doesn't mean that the trial court couldn't. As long as I can't hear something on that recording that proves that he's not laughing. And the second thing is, even if we think he's not laughing, the fact that he doesn't say it in a joking manner doesn't mean that it's not a joke. The phrase itself, I think, as the state court said accurately, I think, the phrase public pretender is a joke. And you can say a joke with a straight face. Sometimes that's the manner of delivery is part of the joke. So it doesn't mean that he doesn't have to say the joke while he's laughing or in a joking delivery. And I think a reasonable officer would interpret this public pretender as a joke. It's a joke about the public defense bar. As the state court, or excuse me, the U.S. District Court noted, Judge Ludwig, he said, well, he's not joking about his right to an attorney, but he is joking about the public defense bar. So I mean, it's a joke, I think.
But it seems, I guess, going back to Judge Jackson Kimmy's point, you know, at one point he says, when Detective Chavez says, you said it right, pretender, there's laughter. And then Detective Chavez says, they're called public defenders. Jones goes, oh yeah, right? Right. Indicating perhaps to some that he was just familiar with the language that he heard from other people, and he didn't really know the formal terminology of what they're called. Is that another way of reading or listening to the audio?
That's a reasonable interpretation, Your Honor, but I think that the state court's interpretation was also reasonable. And I want to sum up because I've only got 30 seconds left. I think even if we think he's not laughing, which I think it's a reasonable interpretation that he is, and even if we think this isn't a joke, which I think is even much harder to say isn't reasonable, it's still a question. It's not a request. I want a public defender right now. So y'all can get a public pretender right now, almost 2 a.m, and of course they all interpret it as a joke. They busted out laughing, and then he says in the transcript at one point, he says we made a joke. So he seems to say that he made a joke. It's docket 10, page 136 of this court's docket. So it seems that my time is up. So unless there are further questions, I will turn the podium back over.
All right, I see none. Thank you very much then. Anything further, Mr. Malkus?
Just in regards to the unreasonable determination of facts, I wanted to emphasize that at the suppression motion hearing, there was no testimony at all from the detectives or Mr. Jones regarding Mr. Jones's tone of voice, whether he spoke in a non-serious manner or with a hint of jest in his voice. There was also no testimony at that hearing in regards to laughter, and so I know that the respondent just cited the suppression hearing testimony. That is not a basis for the state court's fact finding on Mr. Jones's tone and laughter. The state court judge at the trial court level was very clear that he said, to my ears, it sounds like he's just joking and speaking in a tone of jest. So the state court was relying solely on the recording itself to make its factual findings. The recording itself does not in any way support the state court's factual findings, which makes those findings erroneous and clearly so. And then just to highlight that I know opposing counsel mentioned the words "right now," and that was used to indicate that maybe Mr. Jones wanted a public defender, but he didn't want one so badly that he was refusing to not answer questions. I think that that's the concession that Mr. Jones did have a present sense desire to consult with counsel and that he was not joking. Thank you.
Thank you very much. Thanks to both counsel. We will take the case under advisement. And we are now ready to move on to our final case, case number 6 for today, United States against Fernelli Yanos, appeal number 212751. So, Mr. Schwarzbach, if you're ready, we are ready for you.
Thank you. Please the court. Your Honors, my name is James Schwarzbach, and I represent the defendant appellant Fernelli Yanos in this matter. And the crux to this case was initial fundamental unfairness that occurred in the initial prosecutions by the U.S. Attorney's Office for the Northern District of Illinois, which then created an unfair scenario in the sentencing of the defendant in 17 CR 509. I am appealing the decision of the court on the violation of supervised release and the additional 30 months of consecutive sentencing that was given by the district court on September 9, 2021, after the July 13, 2021 sentencing in 09 CR 373, where the defendant was given and is currently serving 120 months.
So just to start on common ground, though, when somebody commits another crime while that individual is on supervised release, the government is entitled, if it wants to prosecute that crime and also to revoke supervised release. And that seems to be what happened here. And in particular, when Judge Guzman looks at what Judge Wood had done, and you look at what the guidelines range was for the offense in front of her, it was 262 to 327. She pulls it all the way down to 120, the mandatory minimum, and she says at one point, you know, whether it was one offense or two offenses, you know, this is what I'm doing. So yes, he does get the extra 30 for the revocation of the supervised release, but why is this so unusual? And why is it out of line for the judges to have handled things this way? And I gather we're focusing on Judge Guzman's extra 30.
We are, yes, Your Honor. And Judge, we have to go back to a ruling that Judge Guzman made in this very case on May 26, 2011. And that brings us back to the nature and the unusual circumstance that both Judge Guzman noticed on May 26, 2011, and Judge Wood observed and commented on at length in dropping below the 262 to 327 guidelines, because those guidelines were unfair in the first place based on the manner of the prosecution.
Right, but it was a big discount that she gave in recognition of that.
It was a discount that should never have had to have been given. That's the problem in this case. In 2007 CR 473, the defendant was charged by the U.S. Attorney's Office by one arm of them in 2007 for acts and conduct that occurred in the distribution of narcotics, and the defendant is guilty of all this. But that's not the issue here. He was charged for an April to July 2007 distribution. He was convicted in 2008, and he was given 70 months in the Bureau of Prisons, and was in the Bureau of Prisons when the same U.S. Attorney's Office charged him for conduct of overlapping time without intervening arrest and for the purchasing of narcotics that occurred between 2006 and May of 2007. These were
Mr. Schwarzbach, I think we do understand the interplay between the 07 and the 09 cases and what happened. I'm particularly trying to understand your argument. It looks like Judge Wood took all that into account, knocked him down to 120. Is your argument that he really shouldn't have been higher than even 70, which is what Guzman then knocks him down to later in the underlying 09 case, and so that even the 120 was inflated, and so then you wanted Judge Guzman on the supervised release revocation to acknowledge that gap between 70 and 120? What was your principal argument in mitigation
Your Honor,
for Judge Guzman?
Thank you. Your Honor, our principal argument was that Judge Guzman himself recognized on May 26, 2021, in correcting that portion of the sentences that he could, which was the concurrent sentences, and he gave concurrent sentences because he found the relevant conduct was sufficient that these could have and should have been one conspiracy. That is extraordinarily important because it placed by the courts still having to go by the law in saying that he had two separate convictions when he should have been only charged with one conspiracy and had only one criminal conviction, meant that he had higher criminal history points, he had higher category, he was categorized as a 6, category 6. He had minimum bottoms on him because
but when he gets to Judge Guzman for the supervised release, he's category 3.
Judge Guzman was operating on the 09 case as a category 3 in a grade A criminal offense because Judge Guzman was taking him as he was in 09. But the fact was, Judge Guzman was the judge that he had originally determined the initial unfairness, and it determined that was the law of the case at that point. Judge Wood, in a very balanced decision, realized that. Now, the U.S. Attorney's Office had the ability, because of the initial discretion the U.S. Attorney's Office had in how they were prosecuting this man, to go up to 327 months, between 262 and 327. And Judge Wood, I'm trying to answer your question, Your Honor, because your question can only be answered by me explaining how I believe that Judge Guzman was not reasonable under our standard of review in looking at how Judge Wood had looked at this situation. Judge Wood saw this for what it was. She actually looked at Judge Guzman's May 26, 2011 determination of the relevant conduct, that these two criminal offenses, which had to be considered separately and therefore raising category, raising criminal history, and putting him as a career offender, put this man up at 262 to 327 years. That was blatantly unfair. And she said so. She put him down.
Let me ask it a different way. At the supervised release revocation hearing, what do you argue Judge Guzman should have done differently?
Judge Guzman should have made a reasoned, and it goes to the judicial review. We give broad discretion on violations. There's no argument that there is tremendous discretion given in the violation of supervised release, and that is what in fact occurred here. But that doesn't mean that there's no judicial review. Judge Guzman had to address my principal argument. That is the Villegas-Miranda case. That is the Cunningham case. He did not address the principal argument of the initial unfairness that put the defendant up at that 120-month limit.
So were you arguing for a sentence of 0 as a supervised release violation punishment, or something less than that? I would love to know your direct answer to
my direct answer is that
question.
My direct answer is because of what the United States government did in 2007 and 2009. The defendant was facing much larger sentence.
I know all about
it should have been 0.
So the bottom line of the supervised release proceeding should have been what? 0 months extra imprisonment, 10 months. He gets 30, which is the bottom of the recommended range. The guidelines were 30 to 37, but Judge Guzman could very well have stated, and reasonably stated, and should have been reasonably stated, that the 120-month on the predicate offense that was given by Judge Wood 2 months earlier was in fact a reasonable sentence. We believe that was reasonable.
Counsel, having done a bunch of these hearings myself in a district court over a 10-year period, when a district judge is faced with a violation of supervised release and the violation is admitted to and you go to sentencing, the first question that I would ask is, well, did the judge in the underlying case consider the fact that this crime was committed while he was on supervised release, right? And if the answer is yes, then there's some weight I give to that. And if the answer is no, then that's something I consider as well, right? Here, from the transcript, it seemed like that's exactly what Judge Guzman did. He asked himself, well, so the defendant was on supervised release. There was a court order that required him to meet certain obligations. He violated that. He admitted he violated that. So the question before Judge Guzman was, how much should he be sentenced to? And then he, I think, reasonably asked, well, did Judge Wood think about that when she came to her 120-month consideration? He found that Judge Wood did not. So he said, okay, well, I believe that he needs some sort of punishment for that additional violation. I'm going to give him 30 months. Why isn't that a completely reasonable approach given the record that was before him?
Because, Your Honor, there was a misreading by Judge Guzman of the actual transcript. On page 71 and page 72 of the transcript of proceedings on July 13th, 2021, Judge Wood states, yes, this man was on...
Well, so she knew, she indicates on the record that she was aware of the supervised release, but reading her remarks as a whole, Judge Guzman understood this to say, and I have to say, in my view, reasonably understood it to say, even though that's a factor, actually what's driving my sentencing decision is the underlying offense, you're incorrigible, whatever, you know, and so I'm just going to leave it at 120, and I'm, you know, in the exercise of my 3553A discretion, this is what it's going to be. So he finds that she knows that it's there. It's not that she's oblivious, but it's not a driver of the sentence. And he then proceeds, as Judge Lee said.
And Judge, thank you very much. I know that I'm out of time. I'll only respond by saying...
You can respond to that, and then we'll wrap up.
Thank you. Judge, I'll simply say that he did not respond under the law as required by this narrow scope of review to our principal argument in that regard.
Okay.
Thank you, Your Honor.
Thank you.
We do ask that you overrule the court. Thank you.
Ms. Moran.
Good morning. May it please the court. My name is Kirsten Moran, and I am appearing today on behalf of the United States. We're requesting today that this court affirm Mr. Yanos' sentence. In the underlying sentencing proceedings for Mr. Yanos' supervised release violation, Judge Guzman took careful steps to assess whether Judge Wood took into account Mr. Yanos' supervised release violation when Judge Wood imposed her sentence. And we know this because Judge Guzman read and evaluated Judge Wood's transcript, asked questions of the government regarding Judge Wood's thought process, and called her analysis thorough and balanced. Judge Guzman clearly acknowledged that he was aware Judge Wood knew about the supervised release violation during the sentencing. It wasn't lost on Judge Wood that this had been committed. This underlying offense in the 17 CR case had been committed.
Where do you see Judge Guzman addressing what Mr. Schwarzbach says is Mr. Yanos' principal argument, which is that the 120 was itself too high, too unfair, and therefore he wanted Judge Guzman to take that into account in the revocation sentencing? Where in Judge Guzman's brief remarks do you see that argument addressed?
When Judge Guzman discusses the thorough and balanced findings in Judge Wood's sentencing, he notes the analysis that Judge Wood gave, says that he's considered it, it's thorough and balanced, but then pivots to his consideration and his evaluation of what's at issue here. And his evaluation is the breach of trust from this supervised release violation. It's not the underlying criminal offense that Judge Wood was sentencing for. Here, Judge Guzman was responsible for the violation of his...
I'm not asking you what Judge Guzman was focusing on. I'm asking you where Judge Guzman addressed what Mr. Schwarzbach says his principal argument is. So your answer is it's in that brief reference to Judge Wood had a fair, thorough, balanced approach here.
Yes,
into the sentence.
Judge Guzman does address several times Judge Wood's reasoning in the conversations with the government, the back and forth with the government, and then yes, Your Honor, in that statement where he does address how he evaluated Judge Wood's own analysis in imposing a sentence. And with respect to, again, the level of delineation of knowledge between what Judge Wood knew and what Judge Guzman was able to interpret, this analysis was appropriate because Judge Guzman, Judge Wood, again, they were just evaluating these two separate violations. Judge Wood looking at the underlying criminal conduct and Judge Guzman evaluating the violation of his own supervised release order. And I briefly wanted just to note the procedural challenges such as this one. They are evaluated under a highly deferential standard, the narrowest judicial review of judgments that this court knows, and as long as this sentence is not plainly unreasonable that it should be affirmed. And with respect to just Judge Wood and Judge Guzman's evaluation of the supervised release violation, that actually was not the end of Judge Guzman's assessment of what occurred and what prompted the 30-month sentence. As Judge Guzman's sentencing transcript shows, after the discussion of Judge Wood's assessment of the supervised release violation, and in fact his assessment of her more generally, considering the underlying conduct, Judge Guzman then goes on to consider other factors, including the 3553A factors going into...
He never actually says that's what he's doing, though, does he? I don't think he mentions 3553A.
Judge, I don't believe he explicitly references the statute. He does go through history and characteristics, the nature and circumstances of the offense, the need for deterrence, all hallmarks of the 3553A factors that district court judges are uniquely familiar with. And in fact also referenced the defendant's allocution, the arguments that the defendant had made in mitigation, and then also the need again for deterrence, talking about the blatant disregard for the court's supervision and the defendant's violation of that, which again differentiates what Judge Guzman was doing in his supervised release proceeding versus what Judge Wood was doing in her sentencing proceeding in the 17 CR case. The sentence provided by the district court here, this 30 months, this was within the guidelines range. As Your Honor noted, it was in fact the lowest end of the guidelines range, and as such, the district court was only required to provide a very concise explanation of reasons here. And the district court here more than satisfied that requirement. Judge Guzman evaluated both what occurred in the underlying 17 CR case with Judge Wood, then went on to assess the 3553A factors, and then decided on this 30-month sentence, looking into the low end again of the guidelines range. If there are no further questions, the government asks this court to affirm Mr. Yanos' sentence.
All right, I see none, so thank you very much. I'll give you one final minute, Mr. Schwartzbach, if you would like to use it.
No, thank you.
Wait till you get up to the podium.
Thank you. Your Honor, I'll only address briefly some of the arguments that my colleague just indicated. With regard to the 3553 factors, we do know that the standard of the burden of proof on this very limited inquiry is the reasonableness, and we look, number one, to whether or not the 3553A or B factors, in fact, in this case, were utilized. I think it's Article 7 of the policy guidelines, but we also look independently at my primary argument and whether it was addressed. But I do want to address what counsel was talking about briefly. And if we look at page 13 of 15, which is document 148, which is in fact Judge Guzman's statement, when he says, he says, I've read the transcript of proceedings, and that begins on page 12 of line 21, and he ends on page 13, line 15, having talked about Judge Wood having given this 120-month sentence. He says, for that reason, I'm going to impose another 30-month sentence. For that reason. And he does not articulate or indicate any response to the primary argument in that. Thank you.
All right, thank you very much. I believe you were serving by appointment. Is that right, Mr. Schwartzbach?
Yes, ma'am.
By court appointment. We thank you very much for your efforts on behalf of your client and the assistance to the court. Thanks as well to the government. The court will take the case under advisement. We will be in recess.